on August 27th, 2024. And then she was absconder, I guess. She was to report monthly.
Yes.
And so we get August, September, October, November, December, January, where?
And she was arrested in March of 25.
February and March. 7 months goes by. And then she gets arrested. She didn't report. She gets arrested.
Yes.
340 days. Okay. Okay. All right. Okay. So here we are. Mr. Turk is with Ms. Stafford and the state's attorney and our probation officer in this case. And the defendant had previously pleaded true to allegations 1 and 4 of the first amended motion to revoke probation filed on September 30th of 2025 in this case. And anything anyone wants to add from here? State?
Nothing from
I think we're going to move forward one way or the other. We've had enough time to figure this out, and if we're not going to get help from Louisiana officials, there's nothing we can do. We can only take care of Texas. So what says the defense?
Judge, just I think Ms. Stafford may want to speak to this in a few seconds, but I was wondering, so she did plead true 1 to 4 without a whole lot of fanfare. She came in and owned up some stuff. One of our initial settings with the court. Since then, we've been trying to work this out with some court conditions that the court imposed. She complied with rather quickly. The state hasn't been able to verify some of the information, but she does, from what she is telling me, have some plans with MHMR and Spindletop to where she could, if she were to be able to get out and get reinstated, she could go there, get the help she needs. Apparently housing, GED, place to work and whatnot, that she could take advantage and start paying back the restitution that the court has ordered on the underlying cases. She knows she made bad decisions with her probation status, with some drugs and whatnot. But some of that was she was transient and didn't have a home.
How much was paid back on restitution, if any?
Nothing.
Nothing.
But she was homeless, Judge, without a job. And so if she could get help with getting a job, that might lead.
Didn't stop her from committing a burglary. Didn't stop her from using drugs. Didn't stop her from failing to report. Come on.
She has been doing well, and she has been incarcerated. She's clear-headed, hasn't had to worry with drugs. I think she's seen
I agree. I think
she's seen the error of her ways, and
incarceration seems what's best for her and her actions. It seems certainly has not proved to be a harm to the general public, except for the costs of the taxpayers to house it. But it's incarceration that keeps her from using drugs, and we know where she is because she doesn't report when she's supposed to. She's been on probation since July of 23, and that's 2.5 years. And it's failing. She's had a fair opportunity. Question is, what do we do? And I hear you want to continue on probation. What's the state say?
Your Honor, she still owes the $23,835.
She hadn't paid a dime.
No, sir.
So I mean, keeping her out for 2.5 years has resulted in nothing except her spending whatever she can for buying drugs that she's test positive for: meth, amphetamine, ecstasy, and marijuana.
Just obviously leave it to the court for whatever you think is appropriate for that amount of restitution that's still owed and has not been paid in this case.
Can't you see? Yeah, it's hopeless under these circumstances. If not one penny has been paid in 2.5 years.
Judge, would you like to hear from Ms. Stafford?
Yeah.
Judge Stephen, I know it don't look right. It wasn't right what I've done.
No, it's not. It's clearly wrong. You committed a crime. You committed crimes while you were on probation in the drugs. You bought drugs, used drugs. That's all crime. Every one of those are crimes, felonies. Some of these are felonies. Methamphetamine possession is a felony, for example. And you didn't report. You scampered off. You went AWOL. We can't help you when you scamper off and disappear. That's the one thing you have to do. If you can't do anything else, is you've got to report regularly, or else you're really not on probation. You're on your own probation, which is failing. Your probation, while you supervised yourself, you went out and got into drugs. So
If you give me a chance to vote.
I gave you the chance, ma'am, when we placed you on probation the first time. How many chances do you get? How many chances? Everybody is subject to the same thing. We told you hey, as you know, the actions have consequences. And if you violate your probation, only one violation is enough to grant a motion to revoke probation. Your probation can be revoked. You can be sentenced up to, in this case, up to 10 years in prison, even though this was a second-degree felony. You were placed on regular probation, so the cap is 10 years, even though it would have been up to 20.
Can you just give me a chance to fight for
You had your chance. I opened the door for you. I opened the door for 5,000 people. Everybody swears that they're going to do the right thing, and 93% of our probationers do. They don't come back and try to explain where they get their drugs, how they got their drugs illegally, committed crimes, and they report. When you don't report, you're AWOL. And I'm going to set an example. They have to follow the rules. If I didn't, then if I treated you differently, then people would say, yeah, I didn't report, but I want the Lydia Stafford rule. She didn't report. And then when y'all caught her, then she got another chance. That's what I want. You are fair, aren't you, Judge? Well, I want to be fair. I'm going to treat everyone similarly in the same situation. You can't go out and go AWOL for all this time. You can't go out and use drugs and then say, okay, I'm going to really follow the probation this time. You've had your chance, you know. Let me see the pre-sentence report if you would be so kind. Thank you.
Nothing but new cases.
Oh, yes. And you were originally charged with 4 separate burglaries of homes, and the state proceeded just on one.
No, Your Honor, she's on probation for all 4.
All 4?
Yes, sir.
Okay, hold on. So, all right, then I misspoke. We are also dealing with 23 CR 342 probation, where you were placed on 10 years imprisonment, probated for 10 years. 343, 23 343, another burglary, sentenced to 10 years and probated for 10 years. And finally, a 4th burglary. So you were on probation for all 4 burglaries: 341, 342, 343, and 360, correct?
That's correct.
Well, we need to go through all those.
There's some motion touch.
Well, I know, but she has to enter pleas of truth.
I think she entered.
I believe she did before you. That's what I have it on my sheet, Your Honor. That each one of them she pled truth.
Okay, and each of those, you're right. She did enter pleas of truth back on October 6th to the same failing to report any use of methamphetamines. Which case is it that is the restitution?
There was 0341. There was $14,700.
I'm sorry.
03.
So I've got my pen now. Go ahead.
And
Start over from the beginning.
Okay, and 341. It's 14,000.
Hold on. Stand by. Yes. Hello? Yes. Yes, sir. Thank you. What do we need to do about that? What do I need to do about it? Oh, yes, sir. Where, on the water tank, where's the water level? Show. There's a device on the tank that is a level. Okay. Good. Awesome. All right. So, who is it? In Johnson City, who would recommend? Gave us. What, what about Blanco? You know anybody? Uh, uh, yes, sir. There you go. All right. Well, yes, sir. Okay. Yeah. All right. But thank you for turning out. Uh, where was the level on the propane? Okay. So it was low. Okay. Uh, well, I'm glad we saved it. So, okay. Now, I appreciate you so much. Thank you, sir. Okay. Well.
Okay, we're back here, and that is correct. The defendant had entered pleas of true to allegations in each of these four cases, to allegations 1 and 4. And which is the case that has the restitution on it?
341, there is $14,700 in that case.
How much?
14,700.
Okay.
And then in 360,
Yes.
there's $9,135. It's $9,135. And the total that I have is $23,835.
Okay, good. Thanks.
Yes.
All right, anything else to add from anyone here?
Judge,
Go. Yes.
I get the sense of where this is headed, so just making the argument that Mrs. Stafford has been entirely compliant with everything the court has requested of her up to this date. She has been trying.
No, she has not.
Well, since
She submitted
the revocation.
Those are all serious violations.
Yes, sir. And she pled true, and the court had requested some information from her. She provided the court with information. The state had yet to verify it. She did admit she has a drug issue, which I tend to think mitigates these cases. And as such, if the court is not going to reinstate her,
It's not the truth. It's not. There isn't a condition that you can't use drugs. Yeah, there is a condition you can't commit crimes, and these are all illegal acts. These are crimes that you're committing, not just
I'm taking medicine or controlled substances, but it's illegal what you have done. It certainly was inappropriate not to report. If you can't do anything else, you have to report. That's the basis. If you don't report, you're not on probation. But I've been over that. You just failed. And I'm sorry you did. But I'm sorry for the victims of the burglaries. That's the victims here. You're the ones you're the one who invaded people's homes. And we gave you a chance and heck, people can get shot for doing that.
Can I just get a chance to get my?
You had your chance when we put you on probation in the first place, ma'am. And here we are with a motion to revoke probation alleging not one, but 10 violations. We've already let's see. Yeah, we warned you at the beginning, and I know the probation officer is helping as best you can, but anything else? I'm sorry, ma'am. What state say?
Again, Your Honor, just whatever the court
What are you
thinks is
asking for?
appropriate for this amount of time. Generally, with that amount of restitution, the court has given the maximum from what we've dealt with. So that's we'd have to ask for, Your Honor. We'd ask for the maximum. That's what the court generally gives when there's a large amount of restitution that it does sentence someone to actually repent.
Okay. Anything else?
Judges said Ms. Tapper would ask for the minimum. She has been compliant since this has been filed. She's been trying to do better. I think she has an earnest belief or earnest effort to try to do better. Drugs did cloud her decision making and made it more.
It wasn't the drugs. It was her choices that fouled up. Here's what we're going to do, Ms. Stafford. In cause numbers 23 CR 342 and 343, the court finds that you have pleaded true voluntarily, knowingly, intelligently, and also in cause numbers 341 and 360, you have pleaded true to allegations in each of these cases, to allegations 1 and 4, voluntarily, knowingly, intelligently. That is enough to grant these motions to revoke probation by a preponderance of the evidence or greater, and your probations are subject to revocation. I am hereby revoking your probations for your violations of probation in cause numbers 23, 342 and 343. Your probations are revoked in those cases, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for time you have served in accordance with these cases, which should, there's just at least 340 days. And that will limit the time you're going to be in prison. It will limit it. In cause numbers 341 and 360, the court finds that there is enough evidence to revoke your probation in those cases. I am going to nonetheless continue you on probation on those two so that you can pay something back to these poor people who I feel sorry for. You still owe restitution in the amount of $14,700 in cause number 341, that burglary of a home, and restitution of $9,135. You're going to continue probation. If you fail on those, you are subject to, as you know, revocation and 10 years imprisonment on each of those cases. Don't think I won't assess that if I feel like you are not trying. You have been on probation for years now, and you have paid nothing back. But you have gotten into drug trouble again, and you have walked off the job and failed to report. That's irresponsible. You have to pay a price for that. And I'm holding you accountable. Anything else to add? That is all. Thank you. I just wish you would do better.
What we just witnessed is a textbook example of how sovereign citizen arguments collapse the moment they collide with actual courtroom procedure. Throughout this hearing, Mr. Haywood repeatedly attempts to separate himself from the legal identity named in the case, insisting that the defendant is merely a registered trade name, a corporate fiction, or, in his words, a piece of paper. This is a common tactic used in sovereign citizen ideology, where individuals argue that courts only have authority over legal entities, not living people. The problem? Courts have rejected this theory consistently in every jurisdiction for decades. Let's break down what actually mattered legally here. First, the judge correctly identified that Mr. Haywood failed to appear multiple times and failed to serve a previously ordered 4-day jail sentence. Regardless of how he labels himself, the court issued a lawful order, and compliance with that order is not optional. The judge even demonstrated patience by quashing one warrant due to procedural posture while still addressing the unresolved sentence in the other case. That's not overreach, that's judicial restraint. Second, the argument that the state is a foreign corporation or that the prosecutor lacks standing has no legal basis. Jurisdiction in criminal cases comes from the court's authority over the offense and the individual physically present before it. And once Mr. Haywood walked into that courtroom, responded to the judge, and engaged in argument, jurisdiction was firmly established, whether he acknowledged it or not. Courts do not require a defendant's consent to exercise lawful authority. Perhaps the most revealing moment came when Mr. Haywood claimed he attempted to deliver the defendant to jail but couldn't because the jail wouldn't accept paper. The judge's response was both factual and telling. Jails do not house documents, they house people. That single exchange highlights the core flaw in the entire strategy. The law recognizes people, not philosophical word games. Emotionally, this case escalated because Mr. Haywood repeatedly interrupted, refused to follow courtroom rules, and attempted to leave after being placed in custody. At that point, the judge's role shifted from patience to enforcement. When the judge warned that leaving would constitute felony escape, that wasn't a threat. It was a legal reality. And moments later, we saw that reality enforced when deputies took him into custody, demonstrating precisely the jurisdiction he insisted did not exist. From a broader perspective, this case shows why courts respond decisively to sovereign citizen tactics. These arguments don't just waste time, they undermine court order and public safety. Judges are obligated to ensure proceedings move forward, rulings are enforced, and defendants are treated according to law, not personal belief systems. So here's the question for you. At what point should courts stop entertaining arguments that have been universally rejected? Should patience have limits when a defendant refuses to acknowledge basic legal authority, or did the judge give exactly the right amount of leeway before stepping in? In the end, the outcome was clear. The warrant was served, the sentence was enforced, a new court date was set. And the court's authority was reaffirmed, not through argument, but through action. This wasn't about paper versus people. It was about accountability versus avoidance. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. These cases may be unbelievable, but the law's response is very real.